and problems. So I'll take your lordship through each of these sections, from section 2 to section 7. And in the end, my lord, I would like to address your lordship regarding two judgments. My lord, I think there are two central judgments which the petitioners have relied upon as legal precedents for the principles of law and constitutional principles which the petitioners have placed before your lordship. One is the Kakar case, PLD 2012 Supreme Court. And the other is a recent judgment of this court, the Ghulam Muhyiddin case. Now, if the petitioners are correct in terms of their reading of these judgments, then in terms of these judgments, this law would be unconstitutional. So my submission on this legal precedent would be crucial. I'll be making the submission that as far as the Bas Kakar case is concerned, PLD 2012 Supreme Court, that is clearly distinguishable in terms of the law which was involved, the Contempt of Court Act 2012. But as far as Ghulam Muhyiddin case is concerned, which concerned the Review Act which was part, I would be respectfully submitting before your lordship that parts of those judgments have to be revisited. Not the entire judgment, but parts of that. My lord, let me come to my...
have to be
revisited. But only parts of that judgment, my lord. My lord, if I may take your lordship to my first submission. And my first submission as his lordship, what I've done is that I framed the questions and then I framed short answers and then I'll make submission. Let me just read the question. The first question is, and this is a question I think which has been troubling her ladyship, Justice Aisha Malik, whether the term law occurring in Article 191 Constitution 1973 includes acts of parliament, whether the term law occurring in Article 191 itself confers legislative competence and or requires legislative competence to be based on some other provision of the Constitution and or legislative entry in the 4th schedule. If the Parliament has the power to enact a law, enact such a law, then what are the limitations of such a law? My lord, if your lordships may turn to the 3rd page of the brief note which I've given your lordship, and the heading is B, where I deal with this question. Now, my lord, the term subject to law. Now, question has occurred and repeatedly been asked, is this conferment or is this restriction? What I would be submitting before your lordship is that it is both. It has two parts, subject to and law. So subject to restricts and law confers. Now, let me first clear I think it is a confusion which has occurred, whether the term law as used in Article 191 means or includes acts of parliament or not. My lord, in order to understand this, my lord, let us first go to the Supreme Court rules and let us examine how the Supreme Court, full court in 1980 which sat, looked at this term law, and the answer lies in that. If I may take your lordships to the Supreme Court rules, Order 11, which is the critical section dealing with the Chief Justice being the master of the roster. How did they understand this term law? If your lordships have Order 11, my lords. If I may read, and I'll only read the first line, critical line, save as otherwise provided by law or by these rules. Now, your lordship may notice the language in this. Save as otherwise, critical word, otherwise, provided by law. My lord, a bare reading of this provision shows that one is envisaging some kind of statutory law. And I will come to the words otherwise later. Otherwise indicates that if law here refers to act, there may be some other arrangement in some other statute.
Subject to otherwise provided by law what? पूरा पढ़िए ना इसको.
By law.
No, kindly read the whole.
Save as otherwise provided by law and by these rules, every cause.
Or by these rules. Or by these.
Or by these rules, every cause, appeal or matter shall be heard and disposed of by a bench consisting of not less than 3 judges to be nominated by the Supreme Court.
No, this goes to the strength of the bench, not who is to sit on the bench.
Sir, I'm not coming to, I'm simply saying, how do we understand this term law, which occurs in Article 191? An indication of that is given in this order. This clearly implies some kind of statutory law, and I'll come to the words otherwise later when I examine what is the relationship between rules and act. Now, to further clarify that the word law must include an act of parliament, there is a definition section in this Supreme Court rules. Now, your lordship may kindly come to that. If your lordships may kindly see Order 2.
Mr. Siddiqui,
yes,
the question was that if it is only to be an act of parliament, then the constitution might have used the word act of parliament, not that the word law includes an act of parliament. The whole issue was that subject to law, law is a very broad term,
yes,
includes many things, including an act of parliament.
Yes.
And the Attorney General said that we should read into the word law the fact that it's just an act of parliament. Hence the issue as to how to read the word law. तो आप जो बहस कर रहे हैं कि लॉ में एक्ट ऑफ पार्लियामेंट है वो तो अंडरस्टूड है, सिर्फ ये है कि टू द एक्सक्लूजन ऑफ एवरीथिंग एल्स हम इसको लॉ में पढ़ेंगे.
मैं टू द एक्सक्लूजन आर्ग्यू नहीं कर रहा हूं, एंड द रीजन आई एम ट्राइंग टू क्लैरिफाई सो दैट देयर इज नो कंफ्यूजन is to come to my argument about conferment under Article 190. If I may just make one point on this.
You see, there are two issues
yes,
here.
Yes,
yes. I interject now. I'm here to hear you. Please conclude your submissions. If someone wants to ask a question, if you start responding to each query, I don't even know what your argument is. And I would request the honorable members of the bench to at least let counsel complete his submission. Yes, there will be questions, but I don't know what you're going to say next. And if you are faced with questions, I mean, I don't know what I'm to write, and I just lose the chain of thought, and I'm sure you do as well. So, Mr. Siddiqui, please, if you keep responding to each question, we'll be forever. No, excuse me, this is no laughing matter.
Lord,
no, from morning to night on the first day we worked, every second of this court is time of the people who have invested heavily in this institution. 3 full days have worked. Now we are on the 4th day. We can endlessly hear one case in the year, and that's a performance. And all the other cases will get left behind, and all they will keep mounting up. So please, there are 15 of us, and all of us have questions, and undoubtedly valid questions. Please complete your chain of thought, and if you keep responding, I don't know what your contention is, I will never understand it.
If I may just complete this.
Please keep submitting your submissions.
I'm very grateful to your lordship. If your lordships may see Order 1, it contains various definitions, my lord, and then your lordship may see subsection 2. If I may read. Unless the context, now law is not defined in the Supreme Court rules, but this provision is there. Unless the context otherwise requires, the General Clauses Act 1897 shall apply to the interpretation of these rules, as it applies to the interpretation of a federal act. Your lordships are aware that the term law is a defined term in the General Clauses Act. And this is the General Clauses Act 1897 I'm talking about. If your lordship looks at section 3, subsection, sorry sir.
Order 1, 2, 2 है ना जरा clear कर.
जी.
Order 1 का rule 2 का 2.
जी, rule 2.
जी.
Rule 2 ka 2.
Ji, ji. Ji, rule 2 ka 2. I'm sorry, sir. So the definition of what law means in Order 11 would come from the General Clauses Act. And Section 3, subsection 37B has a definition of law. It says Pakistani law, but the case law consistently says where the term law means Pakistani law, that is what Pakistani law is. And it says Pakistani law shall mean any act, ordinance, regulation,
Where are you
rule,
reading
order,
from?
bylaw.
Please tell us where you're reading from.
Sir, Section 3, subsection,
Sections तो नहीं है. इसमें
Sir,
कोई.
General Clauses Act, 1897.
अच्छा, we are still at the rules, जी.
Sir, rule तो मैंने आपको बता दिया.
जी.
Order 1, sub rule 2. अगर आप General Clauses Act देख लें आप, Section 3, subsection 37B.
Pakistani law.
So there is, as the Supreme Court which sat while making these rules was clear in their minds.
It
What-
says Pakistan law.
Yes, and the case law says that where the word law comes in statutes, and I've given the citations, I won't repeat them, that Pakistani law's definition is to be used. I've cited that. So, my lord, there is no doubt about the fact that when the word,
This is the book that I
मुझे नहीं
have,
मिल रहा है, अपने निकाल के देना.
there's a note here saying that this was substituted in 1981.
Ji. Sir, 37B.
Yes,
It was
yes.
substituted in 1981, what you are reading. So when the full court sat to frame the rules in Supreme Court Rules 1980, what was 37B then?
But it would still apply.
No, but what was it?
I'm not aware of that, but
Check.
yes. So, my submission before your lordship is that even if one looks at the structure of the sentence, save as otherwise provided by law, the contemplation in the mind of even while framing the rules is that there can be an act of parliament. Now, what is the relationship between that act of parliament and the rules? That is a crucial question. But there can be no question about the fact that rules, act of parliament can be on practice and procedure of the Supreme Court.
No, it can't.
So that's my first point.
No, just a moment.
Ji, sir,
You
ji,
are-
sir.
First of all, you are asking us to read a definition which does not say law but says Pakistani law in the specific context of Article 191 and the Supreme Court rules. Chalo, okay, that's your argument. But you say that law.
I don't know what you say. I still have to note it. Can you please complete your thought? So let me understand what you're saying. So then the question, I will understand the question also. Maybe I'm not so quick at understanding. Can you please complete your submissions from your own mouth? Let us hear it.
My submission is that the word,
Let me first ask up to whatever you've said
Please,
now.
can you I don't know the question has to follow a submission. Please, can you conclude your submission, Mr. Faisal Siddiqui? Otherwise, we'll have to spend forever on this case.
sir, may
आप जरा अपना conclude कर लें submissions.
I just, thank you, sir, thank you. Sir, my
I
submission.
can't follow what you're
Yes,
saying.
Sir, my submission is that the word law, as it occurs in Article 191, includes acts of parliament. And an indication of that, a clear indication of that is given in the rules as framed in 1980, because the language, for example, used in Order 11 talks about save as otherwise provided by law. That clearly indicates that one is talking about statutory law.
Okay, next point.
Yes, yes.
just before
And
you carry on,
that
just-
of course is buttressed by the definition.
Just before you carry on
Ji,
to
ji,
your
sir,
next point,
ji.
I think, if I may ask, in the 1956 Constitution, you will recall that there was a specific article which said that words and phrases not defined in the Constitution shall have the same meaning as in the General Clauses Act.
Yes.
That was in the 1956 Constitution. Is there any equivalent in the 1973 Constitution? As far as I can.
I don't,
Mr. Faisal
I-
Siddiqui, you have
I'm
been
not
right.
aware of it.
You have been rightly
But
stumped.
therefore-
Please persist
Therefore,
with your submissions.
Therefore, my question to you is that here we have to look at the word law as used in Article 191, because the rule-making power is conferred by Article 191. So any definition, anything that goes in the Supreme Court Rules 1980 has to be consistent with the language of Article 191.
I'll come to that. My short answer,
Kindly you focus on that.
Yes.
What does law mean over
yes.
there?
My short answer to that.
I think council.
Sir, I'll just complete
no,
my
I
submission.
think council is entitled to argue any which way they want to.
Achha.
Let us hear you.
Yes.
I have to hear you decide what you say, and if we have already formed opinions, we can reflect them in our judgments. Please
Not a
continue.
question.
Otherwise,
I'm
we
sorry,
will
this is
never
not a question
conclude
of
these
forming
hearings.
An opinion. This is a question that, as a judge of the court sitting on this bench, I am entitled to ask.
Of course,
counsel.
ask it. Let the
So I'm
council
asking the
finish
coun-
his submissions.
If I'm interrupted all the time, I'm sorry to say, sir, that is not proper.
I think the
I'm
interruption
asking-
is of
I'm
learned
asking-
council.
I'm
Chale
asking
learned council,
counsel-
आप आगे बढ़ें.
I am asking counsel a question, which is my right to ask the counsel. If he wants to answer
After
it or
he
doesn't
concludes
answer
his
it,
submissions with
if
the
he
greatest
wants to
of
or
respect.
Doesn't want to, that's his issue. That's not my issue. You understood the question now?
My lord, I'll address that question. Let me just finish this submissions on competence and then I'll address this question. My lord, so I think there can be no doubt about what the word law means in Article 191 in the context type. But if your lordship requires a constitutional context, then subject to law also occurs in the constitution. And it has been interpreted by your lordships of what that means. And that has been interpreted as meaning an act of parliament. A recent judgment on this is a judgment authored by Justice Mansoor Ali Shah Sahab in the extension case, which is PLD 2020 Supreme Court, page 1. And your lordships are aware, if your lordships look at 243, sub-article 3, which contained the same language, although subject to law was not in the beginning, but in the middle. The president, subject to law. And his lordship, Justice Mansoor Ali Shah, in para 27 of that judgment, said this means an act of parliament. So there, another judgment, my lord, on this would be the Baskakar case. Now, if your lordship, as your
What
lordships
case?
are aware,
Bas Kakar.
Ji,
Bas Kakar.
Baskakar.
Okay.
Whether law has been defined in the constitution?
No, no. Existing law has been defined.
Kindly see 260,
Federal law is also.
federal law has been defined.
Ji, law has not been defined. Existing
Federal law
law.
has been
Ji, federal law has
Siddiqui
been
Sahab, please
When-
continue your arguments.
When 191 says of a law, does it talk of existing law or does it include a law that subsequently may be legislated?
It cannot talk about existing law because existing law is a defined term in the Constitution under Article 260. And that is a reference to Article 268, sub-Article 7. So when existing law is used, it's a defined term in the
Okay,
Constitution.
so where it is defined, then the Constitution must have used the term existing law somewhere.
Yes, in
Where is that?
268.
No, no, वो तो
It is in
defined हुई है
260
ना?
It is in 260.
Other than the
260, yeah.
definition, where in what articles, what other articles has this term been used?
It is being used in 268. It has been defined and used in that, as far as I'm aware. But it is a defined term. So if they wanted to use existing law, existing your law would have been used.
Mr. Siddiqui, it seems that albeit the fight is about me as being as a master of whatever, you're not hearing what I'm saying at
Sir,
all. And you're completely ignoring.
No, sir, I'm not.
I mean, you don't want to make
No,
your
no, no, sir,
submissions.
but I'll-
You should just sit down and answer
No, no,
questions.
I'll complete my submission.
So why
Now-
aren't you making your submissions?
No, no, my lord, leaving aside the issue.
Mr. Faisal Siddiqui, just 1 minute.
Ji,
You've given the example of Article 243. The president shall, subject to law,
ji,
have the power to do what? Raise and maintain military, naval and air forces of Pakistan and so on.
Ji.
But the difference between law over here is, and this is the point that yesterday was made with other learned counsel, that this relates to a specific entry of the Federal Legislative List, i.e. entry number 1. Law over here is relatable to entry number 1, a specific entry
I'll come
of
to
the
that,
Federal
sir.
Legislative List. And this was in relation to Article 202.
No, I'm simply saying that the word term subject to law, as used elsewhere, has been judicially defined in a certain, whether Article 191,
There's a context, what I'm asking you is,
Yes.
there's a context to Article 243, and a context that appears to be missing in relation to Article 191, where there is no specific entry, for example, in relation to the Supreme Court. So which particular legislative list would you link the use of the word
that
law?
is where I'm coming to, my lord. When it comes to practice and procedure, I will be relying on entry 58. When it comes to the appellate jurisdiction under section 5, I'll be relying on entry 55. So I'll come to now this submission. I just wanted to clear as far as this word law is concerned. Now, let me come to my first part. As your lordships are aware, there are two parts to this law. One relates to practice and procedure, and then there is section 5 which relates to appeal. Although there is a judgment by His Lordship Justice Munib where he has said as far as legislative competence is concerned, even appeals are a part of procedural law. I'll be referring to that judgment. So, if appeals are also a part of procedural law as far as legislative competence is concerned, then they would even be covered in practice and procedure law. So let me first come to how practice and procedure is covered. My lord, if your lordship may kindly see my note, I rely on entry 58, read with article 191, my lord. Now, my lord, it is, if your lordships accept my argument, which is that subject to law also includes acts of parliament, if I can safely make that presumption, then in order not to make this word redundant, there must be some power with someone to make this law in the Constitution. Otherwise, the word will become redundant. Now, that power, my lord, cannot be based on entry 55. It has to be based on entry 58. The reason I say that is entry 55 deals with, as apart from practice and procedure, it deals with jurisdiction and powers. When one is talking about practice and procedure, one is not talking about jurisdiction and power. I make that distinction. Now, a question was raised as to entry 58. If I may draw your lordship's attention to entry 58. It's quite a complicated entries, both of them, my lord. If your fourth schedule, sir, entry 58. Now, a question arose as to a very important term which is used in both the entries. It is by or under the Constitution. Entry 55 uses the word by or under the Constitution. Entry 58 only uses the word under the Constitution. If I may read, matters which under the Constitution are within the legislative competence of Majlis-e-Shura or relate to the Federation. What does this term under the Constitution mean as opposed to the word used in entry 55 by or under? My lord, this is a term which is used in the Constitution also, by and under the Constitution. It's used once in Article 69. It's used under the Constitution is also used in other parts of the Constitution. Now, I think the answer is something which Justice Ijaz had given, is that under the Constitution means the necessary implications. So that is how at least the Indian Supreme Court has understood this. What necessarily follows from a certain article. It's like something which can be prima facie implied from an article. Now, my submission as far as Article 191 is concerned, my lord, is that it is not something which is very different from the rest of the entries, as Justice Munib had observed yesterday. I think it's a substantive entry. And that is how it's been understood by the Supreme Court in the sui gas case. There's a whole para on entry 58 and 59 that these are independent and substantive entries in the Constitution, which independently and substantively confer competence. Now, my submission before your lordship is very simple, which is that if law in Article 199 means Act of Parliament, and if we are not to read law as in 191 as redundant, then there has to be legislative competence which has to be found somewhere for practice and procedure. Now, that place where it is found can either be entry 55 or entry 58. It cannot be entry 55 because we are not talking about jurisdiction and powers. It has to be entry 58. And entry 58 contains the key words, which is not by the Constitution but under the Constitution, as necessarily being implied. The necessary implication of an article is that it confers judicial power. So that is why one part
So
of
you're
subject to
reading
law,
entry 58 with what? With which article of the
191, and I also
191, you see, as the language, as the simple reading of 191 says, it is a power conferring article, and that power is conferred on the Supreme Court. So ultimately, the rules which have to be framed under Article 191 is a power of the Supreme Court, not of the Parliament.
my lord, there are
But
two conferring
In,
powers.
in,
Ji.
in framing the rules, the Supreme Court is supposed to follow the Constitution, and I would tell you, speaking for myself, any existing law or any law that was prevalent or was in force at that time. Entry 191 does not, Article 191 does not confer legislative power on the Parliament to frame rules for the Supreme Court.
My lord, then the words under the Constitution would have to be given another meaning, because there is express conferment, as your lordships have seen in Article 188, through an Act of Parliament. And there are necessary implications, conferments which follow from the article.
आपका तो entire thesis ये है ना कि जी law का मतलब ये है an act of the
Yes.
Parliament, whether it is existing or it is subsequently made.
Yes, yes.
ठीक है, वो उस सूरत में होता जब 191 में लिखा होता the rules of the Supreme Court shall be framed by the Parliament. Yeah, what was the fun or what was the rationale of giving the power to the Supreme Court in the chapter of judicature and at the same time turn around and say, well, you can frame the rules, you may frame the rules, but once you have framed the rules, the Parliament can override those rules.
Because
by
it is a
an act of the
limited power.
Parliament.
The reason is the structure of 191 is that the primary power, the primary duty under 191 is given to the Supreme Court too, so that its internal autonomy is, but
So where the primary power or the primary duty has been discharged, then the matter ends there.
no, it doesn't end there. That is why your lordship will see I broke subject to law into two parts. There
Because-
is law and there is subject.
Why do I say that?
Yes.
Because the entire structure of the Constitution ensures that the judicial branch shall be insulated from not only the executive but also by the legislative intrusion. Okay? So, conferring the power to the Supreme Court means that insulation has to be maintained. Now, once you confer the power on the Parliament to override those rules, that insulation goes. Because, as it was argued yesterday, or at least it was observed yesterday, that this is an intrusion into the autonomy of the Supreme Court, which is the main theme of the Constitution.
May I address this question when I deal with the relationship between the Act and the rules? Which will prevail in what circumstances?
अच्छा,
Because
ये
that is what
बताइए,
you're...
ये जो amendments हैं, do they or do they not interfere in the internal working of the Supreme Court?
Sir, the criterion is not whether they interfere in the internal working of the Supreme Court.
That is the
No.
criteria
I'll
of
show,
independence.
No, my lord, I will say there are 4 restrictions on Parliament as far as its legislative authority is concerned under Article 191, read with entry 4. Let me first state that, then I'll explain. The first restriction is that under 191, only a law relating to practice and procedure can be made. The second restriction is that Parliament can make no law, whether it's internal working or otherwise, which violates the principle of the constitutional principle of the independence of the judiciary. Number 3, and this might answer your lordship's question. Parliament cannot legislate in a way that it colonizes the power of the Supreme Court to make rules or destroys the power of the Supreme Court to make rules. It's a supervisory power. It's a checking power. It's not a power which can destroy the Supreme Court or paralyze the Supreme Court into making rules. And I think the fourth is that entry 55 and 58 still have to be read harmoniously. Parliament cannot make rules which in any way affect the jurisdiction as well as lessen the power of the Supreme Court.
So
These are the 4 restrictions on
doesn't-
Parliament's powers.
Doesn't the Act affects all those 4?
I will show to your lordship it
that
doesn't.
you have just spelt out.
I will show to your lordship it doesn't when I come to each provision of the law. So these are the 4 restrictions. I'll elaborate on this, sir. But let me
You didn't
come.
answer the initial question.
Yes.
Does it constitute an interference in the working of the Supreme Court?
Sir, I think,
Yes or no?
sir, I would rephrase the question. The relevant question is, does it interfere in the internal working of the Supreme Court to the extent that it affects the independence of the judiciary?
Now,
That's the question.
You used the word supervise.
Yes.
Isn't supervision have an element of control?
My lord, any supervision will have the element of control, but control does not mean, regulate does not mean that
How
you
can
destroy the
control-
power.
How can you control without interfering?
No, any supervision will imply interference. The question is, does it colonize the other person's power? Does it destroy the other person's power? Does it violate the principle of the independence of...
Where the Parliament has made a law that destroys the existing rules, what does it do? It
My
does
lord,
destroy.
it doesn't destroy the existing. Now that is a question which I will address. Relationship, अगर मैं सिर्फ competence अगर खत्म कर लूँ अपील की हद तक, मैं अपील की हद तक क्योंकि I
एक क्वेश्चन मेरा जरा ऐड कर ले
जी
छोटा सा
जी जी जी
आर्टिकल 191 says subject to the constitution and the law. So what does that means? The powers given to the Supreme Court by the constitution are absolute, or is there still a room for interference?
I would not,
Interference means amendment, or
I would not like to use the word interference because it gives.
it's not interference.
Yes.
I'm sorry for that.
I would say that your
But
lordship.
still, the rules are the power which has been given to the Supreme Court. Is that power absolute?
No, it's not absolute.
Because
But
the first word is subject to.
yes, subject means conditional. It is a restriction. It can't take over the power to take rules. It can't paralyze that. That is why I would say that the Supreme Court should be insulated from external pressure. It should not be isolated. So Article 191 creates this balance where the internal autonomy of the Supreme Court stays in the hands of the Supreme Court, but subject to certain restrictions which may be imposed certain conditions which may be imposed by Parliament. I'll come to, because this is a crucial question, and there is a Supreme Court judgment on this, the relationship between rules and act and what prevails. I'll come to that.
If I've understood you correctly, what you're saying is that this is not this law-making power or law as used in 191 is not a fully enabling power, but it is a power of a supervisory nature. Is that what you're saying?
It is a restrictive power.
You use the word supervisory.
Yes, I use the word supervisory in terms of that it is a power which has its limitations. That is why
That was the reason, one reason why I'm asking this is because you're emphasizing on linking this with entry 58.
Yes.
Which you say should be interpreted in the usual way that the legislative entry is normally interpreted.
Yes.
That would seem to necessarily imply that whatever is the subject matter of that legislative entry, it is not as such disclosed in 58, but I imagine would then be the practice and procedure of the Supreme Court. Then surely, if you read it the way you are linking it, then that would, the law-making power would cover the whole of the field of the practice and procedure of the Supreme Court, and thereby, just hang on, thereby become an enabling power and not remain a supervisory or restrictive power of the nature that you are now stating. So there is this tension between what you are saying, a possible conflict. Kindly clarify this point.
My lord, there is no conflict because the language of entry 58 clarifies. Entry 58 cannot go beyond the conferment of power with necessary implication which any article of the Constitution does. So any power in terms of legislation which entry 58 does must be in the context of the power conferred by the Constitution. So if 191...
But that power, in the end, legislative entries confer power, legislative competence over a subject matter.
Yes.
A tax on income.
Yes.
The defense forces, international relations, what have you. The entry 58 of itself discloses no subject matter as such. It simply refers, because this is the point
That is why it is limited by that constitutional provision which confers this power.
Then how do you read it as a legislative entry? Because if you now link it to the subject matter of practice and procedure, that then should
Sir,
surely
if you
covers
don't
the
read it
whole
as a
of-
legislative entry, you will make part of the entry redundant. The part of the entry says or relate to the federation.
That's what I'm saying. That
I mean, it
if-
makes it redundant.
No, it doesn't make. That's my question to you.
Yes, yes.
आपकी जो submission है,
जी,
मुझे समझ
जी,
आ रही
जी,
है
I'm
ना,
sorry, sir.
That seems to me not to be restrictive or supervisory. That would necessarily, if you link it to a legislative entry and the manner in which legislative entries are interpreted, that would have to be given the legislative competence, the power to make the law, the enabling power, whatever you want to put it, would, it seems to me, have to be interpreted in the broadest possible manner, which would mean that it would cover the whole of the field of practice and procedure, which is why Mr. Salahuddin, for example, said that yes, the Supreme Court rules can be repealed by an act of Parliament.
No, I don't take that.
Don't go there.
No,
I understand.
I don't
That's
take
why I'm asking you.
Yes.
So there is this tension
Yes.
between linking it to a legislative entry, because that's how legislative entries are interpreted, and then in the same breath or in the next breath, saying that no, it can't go to the full subject matter. It is restricted to supervisory or limited nature. And
My
how
lord,
do you draw the line?
these are entries which I call ping pong entries, and I'll explain when it come to.
Mr. Faisal,
Ji.
taking the discussion further, and that's very important, what's being discussed. My understanding is, what appears to me so far is that when we have to read 191, straight away when you look at 191, there could be a restrictive meaning given to law, but we don't have to really stop there. We could also say that there could be a law, even plain reading of 191, that there could be a law that would cover the area of practice and procedure, because that's why it's subject to that law. There is a law where whenever Supreme Court goes ahead and comes up with rules, it will look at law. There could be laws relating court fee, there could be laws relating to many things that impinge upon, but at the same time there could be a law which takes care of the whole area of practice and procedure. But when you read it with 58, it does, as my learned colleague also mentioned, makes it very expensive. It says that it covers, it is the subject matter that we'll have to look at. And it appears that when 191 is read with 58, the entry, it appears that there is legislative competence with the Parliament to legislate on the question of practice and procedure. So hence, perhaps what Mr. Salahuddin said, that it can abolish the Supreme Court rules, appears to be then correct. You can't stop halfway. You have to either accept the whole contention saying that 58, when read with 191, gives the legislative power, and then in that case they can go ahead and do whatever they want to do regarding the rules. So that's one. So, but what appears to me is that if 191 is read after reading 58 and you come back to 191 after reading 58, then you look at the legislative competence only, and it appears that then law, when you look at law then after 58, it appears that it gives you that legislative competence.
Happens when you look at entry 55. My position is very different from Mr. Salahuddin's
Ping
position.
pong can go on endlessly. Where does your ping pong end?
I'll come.
I think it's
it's
just
a
one
term-
way, it doesn't go back again to the entry
One
again.
thing would do.
But one more question that I want to add here, maybe you can respond to that also. Is there a difference between the word practice and procedure? Because one would have understand that it could be a procedure of the Supreme Court. What's the importance and significance of the word practice? And I say it for a reason. I say it for a reason because there are judgments of the Lahore High Court while discussing letters patent, saying that this is an internal arrangement in the, they don't consider it as an appeal. They consider it as an internal arrangement of the court, as if it were to pass for a practice. So considering that case law, written by celebrated judges of our courts, the question is, could it then be said that considering that it's an intra-court appeal, it's not an appeal in the appeal sense. That's exactly what the judgments say. It's not an appeal, it's an internal arrangement of the court. Could it then pass under the term practice under 191 to have this intra-court appeal? As you had mentioned earlier, so that's why, is there any significance of the word practice and whether intra-court appeal is for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib. And I'll straight away come to that. Those are three. There is a short order by Justice, it is Justice Mandokhail who actually raised this very important issue through a short order. And then there are two opinions, one by Justice Hassan Azhar Saab, one by Justice Munib.
You might consider these three judgments of the Lahore High Court
Yes,
also,
I
which
can.
are...
But let me just read those because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the two separate opinions. If your lordship will kindly see page...
that was without my opinion. Without my opinion.
लेकिन सर आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked what is your opinion. Without my opinion, it was sent to the.
लेकिन सर आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया, वो देखिएगा आप जरा पेज 9 पे.
चलो मैं उसका जवाब अभी जो खत्म हो गया तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are three unreported orders, my lord, but I think these are such crucial orders should be. If I may first to Justice Mandokhail's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, 5th line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution. Reference is made to the order dated 13/4/2023 passed in Constitutional Petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion, I'll read the last 4 lines. As the issue involved is in this petition is identical to the issue involved in constitutional petition number so and so, therefore let it be placed before the Honorable. Now, on this, a dissent was done by Justice Hassan Azhar Rizvi. Very interesting opinion, my lord, page 12, if your lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the case was really decided on the merit. There's a very important paragraph on this intra-court appeal, which is at page 17, para 14. It's the same it is the same line of argument which Justice Mazhar had alluded to yesterday. Para 14, page 17. As far as the question of whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect to matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution is concerned, so both constitutional forums, intra-court appeal in the law reforms order. I am of the humble opinion that Article 175 of the Constitution, by its clause 1, ordains that there shall be a Supreme Court of Pakistan and a High Court of each province, and recognizes that such other as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of Section 15 of the Code of Civil Procedure Amendment Ordinance 1980, which also provides a right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge, that court in the exercise of its original jurisdiction has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184.3, there is no bar that a right of appeal through a statute cannot be provided. Now, your lordship may note 2 things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number 2 is that it has been held that even if the order is from a constitutional forum, as Justice Mandokhail had pointed out, even then an intra-court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the law reforms ordinance. Page 20.
As a referee judge.
Ji?
As a referee judge, you
Sorry?
Referee
As he
judge.
referee judge, sir. Page 20, sir. I may read. Para 3 मैं जरा context दे दूं. On hearing the matter, a different opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhail, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184.3 of this court. Now, let me come to para 4. A difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution, such that Section 3 of the ordinance is a valid legislation. Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read kindly from the last line. One is a right, I move to the second page, that is relatable to a specific entry on a legislative, this is the next page, 24, or to a particular legislative
If I may request you kindly read the whole.
Should I read the whole, sir?
I think
Ji,
that
ji,
may
ji, ji.
provide
But,
some-
ji, sir, ji, sir.
Some background.
But of course, the ordinance was not just an amending statute. It also had Section 3, which provided as presently relevant for a right of intra-court appeal in terms as noted above. That also had to be taken into account while determining its pist and substance on the commencing date. I begin by noting entry number 46 of the concurrent list. This provided in material part the legislative competence of jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. All courts, including the High Court. Right of appeal can, for present purposes, be divided into two categories. One is a right that is relatable to a specific entry on a legislative list or to a particular legislative competence. The other is what might be called a general right of appeal. Now, these are crucial lines. Now, it is well settled that a right of appeal is a substantive right, which must be expressly conferred. However, jurisprudentially, appeals in a general sense are regarded as a part of procedural law. In my view, this categorization is relevant for purposes of legislative competence insofar as a general right of appeal is concerned. Such a general right would lie in the legislative competence relating, as the case may be, to civil or criminal procedure. This conclusion is bolstered by the fact that both entries relating to criminal and civil procedure, number 2 and number 3 respectively, included therein all matters included in, respectively, the Criminal Procedure Code and CPC. Thus, entry number 3 provided in material part as follows: Civil Procedure Code and all matters included in the Code of Civil Procedure on the commencing date. The two codes of course, contain specific provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence conferred by these two entries of the concurrent list, my lord. So, what seems my reading is that as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have a law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it says.
Mr. Faisal, and I think that is echoed, you might not have looked at this, but I found 53 Lahore, 284, and it's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading
Which
it.
actually talks about exactly something like this, which needs to be discussed, which is a letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement of the court for reviewing its own decision,
Yes.
given in the first instance by one member of the court. And then the first as well as the second decision remains a decision of the court. And if you look at Order 5, Rule 2 in the rules.
Yes, there's a chamber
There is
appeal.
a chamber, it doesn't say appeal, it says for reconsideration
Yes.
to a 3-member bench. So, three judges, if you see Order 5, Rule 2. So, I mean, before going into 55, let's sort this out whether at all this could form part of having an
So
intra-court
no,
appeal.
Rule 3, Order 5, Rule 3 says appeal. Rule 3 says an appeal shall lie from registrar in all cases to
As
judges.
registrar,
From
agla pade na.
to the judges in chambers.
That's
It's an
right.
appeal.
And then there is from a single
That's
judge
an
to three judges.
administrative order,
enough.
and that's an administrative appeal.
But it's still an
not
appeal.
a judicial
It's still-
order.
It's still an appeal and it's framed under 190.
Fair enough. I mean, it probably has a color, rightly said by my learned colleague, that it could be administrative in nature, but we need to understand the context. If you look at Order 5, Rule 2, it talks about the power of the court in relation to power.
In relation to the following matters may be exercised by a single
Can you
judge.
tell us where are you reading from?
Order
Sir,
5,
Rule 2, Order 5, sir, Supreme Court rules.
the power of the court.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter. Your Lordship is right.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I've looked at are talking about that it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. Yes. So whether at all it becomes part of procedure of practice and procedure rather than as a substantive.
I think this note opens up that question. If I may just read the last paragraph and then Your Lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case and a paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If Your Lordship may kindly see page 25, para 12.
Para 12.
Ji, sir. Ji, sir.
Ji.
Page 25. In view of the above discussion, I am in no doubt that the question to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my learned colleague Hassan Azhar Rizvi that leave to appeal should be refused and leave petition dismissed. उससे ऊपर जो है 4 लाइनें वो हैं in contrast. My learned colleague Sayyid Hassan Azhar Rizvi has rightly noted in an order. See para 15. Now para 15 flows from para 14, dependent on para 14. That despite lapses of more than 50 years from the promulgation of the ordinance, no such question called the legality of the ordinance has been raised by any party lawyer, any high court or this court, my lord. And para 14 dealt with 2 things. There can be an intra-court appeal from a constitutional judicial forum, and secondly, the legislative competence based on Article 175, sub-Article 2, my lord.
Okay, Mr. Counsel, the thing is that you are of course referring to my order.
Yes, sir.
It is an order of the court, and therefore it is for others to make of it what they will.
Yes.
It is not for me to now read and interpret it, but I am picking up on the point that you think flows from this order.
Ji.
Seems to me, with respect, that it cannot conceivably flow from this order. The reason is that the issue before the court or before me as the referee judge was a right of appeal conferred by statute, right? And as you have read, I have noted 2 kinds of appeal and the jurisprudential aspect of it and the language of entry 3 of the current list and so on and so forth. However, to translate this into practice and procedure as embodied in Article 191, in my view, would, and that is certainly not what this order was about, but would be incorrect. Why? For 2 reasons. One, because the subject matter of practice and procedure, insofar as law is concerned, you have told us that in your view it is limited, restricted, supervisory. It is not the entire breadth of the practice and procedure of the court. So if that is so, then no law which is so restricted, which is of a supervisory law-making capacity, which is restricted, supervisory, restrictive in nature, surely can confer a right of appeal in terms of that subject matter.
I
But
think it can.
secondly, there's just one more. Secondly, and more importantly, the subject matter, practice and procedure of the court is not restricted to the legislature. It is open even to the Supreme Court.
Yes.
It is primarily for the Supreme Court. So one conclusion that would follow from what you are saying is that the Supreme Court can itself create a right of appeal in exercise of practice and procedure. Is this what you are arguing?
My lord,
In relation to Section 5 now, we
My
are the
lord,
context
my
here
lord,
is Section
my
5.
lord.
So tomorrow, the full court amends the Supreme Court rules and creates a right of appeal. Can
my
it do
lord,
that?
my lord, I make two alternative arguments when it comes to the legislative importance
Mr.
of
Faisal,
appeal.
before
Ji,
going to
ji, ji.
answer the question of
Ji,
my lord,
ji.
please complete that page 18, para number 16 of my lord Hassan Rizvi. This is
Sorry?
very interesting para 16, page 18.
Para 16, sir. हाँ सर जी जी ये भी बहुत इंटरेस्टिंग है आई एम सॉरी दिस इज आल्सो क्रूशियल टू दिस मैं पेज 18 पे हूँ सर पैरा 16 it's very important that what Justice Hassan Rizvi has reminded us is very important to be reminded all the time. Para 16. Surprisingly, this question, page 18, surprisingly, this question has also not been raised in this case, but it has been taken up by my learned brother on his own. The process of judicial scrutiny of legislative acts on the touchstone of the Constitution is technically called judicial review. The courts, however, should adopt judicial self-restraint in discharging their functions of judicial review in order to maintain harmony between the judiciary, the legislature, and the executive. The power of judicial review of legislative acts vested in the High Court, and this court must be exercised with freedom, wisdom and self-restraint, and not in a spirit of cold war between parliament or state legislature and the courts. Non-interference with the view of the majority in parliament with regard to what is reasonable and interference with what is prohibited by the Constitution may perhaps be a harmonious path for a peaceful transition for a glorious future. In Lahore Development Authority versus Mrs. Imran Tewana, 2015 SCMR 1739, this court, while stating the rules which must be applied to declare laws unconstitutional, has held that if a case can be decided on other or narrow grounds, the court will abstain from deciding the constitutional questions. So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
sir, I try to read everything which your lordships write,
Our
whether
bodies-
reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if for the purposes of legislative competence, appeal is a part of procedural law. If that is so, then Parliament can also confer appeal
Not all
under
appeals, but intra-quota.
intra-quota. 191 read with 58, and the court can also do that.
Court can also.
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184.3 are not liberating, are not restrictive. They would be liberating, because it is a problem that there is no appeal against such tremendous
No, but
power
you see,
exercise.
this
by-
Order 5, Rule 2 that you read, even
Yes.
though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the party.
Yes,
And the rules are providing for that appeal.
Yes, yes. So this is one way I can, at that legislative competence.
I've recorded your contention, correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes, yes.
Okay.
yes.
And why
They
did-
are not always restrictive,
If I
my
may-
lord.
If I may follow what my learned colleague has said with regard to Order 5, why
I
didn't they
can't
use
hear
the
you,
word-
I can't hear you, I mean, I can't hear you, so
I'm
if
so
you
sorry.
could.
What my learned colleague said regarding Order 5, it's, why do the rules use the word reconsider? Why not simply call it an appeal? Because read it, आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
Which
include.
may include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So
If
this
it
is
were
a
an
review?
appeal, This is
is
not
a
a review.
reconsideration.
This is a reconsideration.
Sir, it is like a review then.
No, it's not.
Review, practice and procedure में review का power confer कर दिया तूने.
ये देखिए ना जी.
अगर,
उसने deliberately ये
In an appeal, can't a judge who passed an order sit?
Sir, that is not the notion of how
No,
things are.
I suppose he's one judge, I
Sir,
don't know. For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the third judge. Alternatively, what could happen alternatively is because one set of arguments were, the third judge hasn't heard the arguments as well, or that particular question as articulated was not put to them.
Yes, yes.
So can the Chief Justice then say, can you all three sit together and decide it? Since now the possibility of a hung court will not arise. It can still go in 3 different ways. So what is that called? I mean, that option is available to the Chief Justice. I'm adding another member on the bench and hear this matter again, or whatever you want to call it.
And if I could add to that, if you look at section 5, you see, I mean, this is a traditional notion, but if you look at section 5 of the law, the one under challenge,
Yes.
it says that the appeal will go to a larger bench. Now, I just, want to understand whether a larger bench could have this earlier set of judges along with other judges, or a new set of judges as a larger bench. So, I mean, where is this restriction inherent? Traditionally, yes, appeal would be heard by, but could there not be a hybrid system where there could be an appeal to a larger bench in this particular situation, which is the apex court dealing with these matters, and that sort of resolves the problem of 4 and 5 also? Why can't 1 or 2 other judges be added to it? I mean, is there a problem somewhere, or does it?
My lord,
is there
For instance, I'll just further add to it. There have been instances where review matters have come up before larger benches, even during the subsistence of the judges who had earlier passed the order, and they are reported cases. So what is that? Is it a classical review will be heard by the same judges? That's simple enough. Now, this matter has been decided by 2 or 5 or whatever, and 1 judge has been removed, 3 have been added. So that judge here, himself being bench, is reviewing the matter, and the others are exercising powers of appeal. Surely they can't be exercising powers of review. I don't know. So these, as His Lordship, Mansoor Isha has pointed out, it may be a different category of animal.
Let me just build on what both your lordships have said. Let us forget about the distinction between appeal and review. Reconsideration.
That is only for the reconsideration, Mr. Faisal.
Ji.
You should kindly read Rule 2, which says the reconsideration by the bench of 3 members. If you go through Rule 4, that is an application for reconsideration under Rule 2, and appeal under Rule 3. Appeal is an appeal live from the registrar in all cases to the judge in chambers.
So let us look at this
There
word
is two
reconsideration.
parts of that. The reconsideration, that would not be considered an appeal, but the appeal is provided separately.
That is
against
against
the order of the registrar in
But
chamber.
that is
And
against
suppose if we
registrar.
were to consider section 5
That
and
is why
consider it
the
as a
word-
reconsideration,
That is why the word reconsideration has been
Does
used,
it-
in which the judge who passed the order may be included in that bench.
Yes.
So it's not a part of appeal, it is not
Yes,
just like
yes.
an appeal.
But let us
See,
and if we were to just say that section 5 is a reconsideration, and
Sir,
let's
may-
not in the word
let's
appeal,
let's
could it
just
not
focus
then
on
pass
this
the
word
muster?
reconsideration. What is happening? Sir, मैं एक बात कर- मैं एक बात कर-
it is not an appeal, reconsideration.
लेकिन ये आप
इसलिए
देखिए,
बैठ
ये
सकते
जो रिव्यू एक्ट जो पास हुआ था, इस एक्ट के बाद उसमें लिखा गया था review shall be heard like an
जी, मैं
appeal.
उस पे भी आ रहा था
And उसके अंदर speaking entirely for myself,
And it was struck
I
down
have
on
given
that.
a concurring judgment in which I have pointed out the serious jurisprudential issues that would arise where half the bench is essentially hearing it as a, because they've heard it before as review, and half the bench is hearing it for the first time, therefore an appeal. You can't mix and match like that.
Sir, let's forget about this distinction between appeal
Constitution
and
की तो constitution
Let-
की
no,
distinction ही
but
खत्म हो जाती है.
let us concentrate about the word reconsideration. Single judge ने order किया है, उसको reconsider कर रहे हैं 3 judges.
But that is on the administrative side, it's not
Sir,
the judicial
उसमें
order.
applications
Right.
decide हो रही हैं. अब reconsideration has become, which is in the nature
But
of a
all,
review.
all those matters in Order 5, even though, well, it passes for whatever we may call it as a administrative, but there's substantive rights being decided.
And they have been made a part of a law which is limited to practice and procedure.
But
So the
Parliament
word
is-
Is
reconsideration.
it
Parliament
on
has called it an
administrative side,
appeal.
Mr. Faisal, or the judicial side?
Ji, sir?
Is this on the administrative side or the judicial side?
This is on the administrative side, sir.
Then why the word use aggrieved party by a bench of not less than 3 members? The bench is constituted.
Yeah, I don't know
The
if this
judicial
is.
side or the administrative side?
Taking that point further, I mean, whether at all these straight jackets about this administrative, moving into judicial,
The
moving
point
into
is-
administrative.
Probably the bard said it best. A rose by name would smell just as sweet.
I would
So
say-
whatever you call it,
I would say reconsideration and order of your brother judge on judicial applications, if that can be considered as a part of procedure and practice, my lord, then just building on what Justice Munib has said in his opinion, why not appeals as a part of procedural law? So, but that's my alternative. But let me come to my main argument, which is legislative competence as far as appeals are concerned. I rely on entry 55. And like Hassan Azhar Saab's judgment, where he relies on 175.2, the judgment authored by her ladyship Aisha Malik Saiba has also relied on 175.2, read with entry 55 in the CCP judgment, which conferred an appeal to the Supreme Court.
You see, as pointed out yesterday, there is a difference between bringing an appeal to the Supreme Court as opposed to creating an appeal against an order of the Supreme Court. So when you are relying on examples where the appeal is coming to the Supreme Court, it's different. The whole, the way of looking at the law and interpreting the law will be different. The question here is not about can this appeal come to the Supreme Court, it's about whether this appeal under 143 amounts to a creation of jurisdiction or whether it is the enlargement of the jurisdiction. I don't see how any of the issues that you are presenting have answered that particular question.
These are two separate
Mr.
questions.
Faisal, I mean, if the appeal comes through a statute or if the appeal comes through a statute like the Competition Act or the Elections Act or whatever, they are enlarging the jurisdiction of the Supreme Court.
That is
Either way, it goes directly into entry 55.
one of the questions which was raised by Justice Ejaz was that if you create a new appeal, is this enlargement or this is, because enlargement would imply something being there that is being enlarged. But your ladyship's judgment includes within the term enlargement in para 62 of the CCP judgment 2021 CLD, that enlargement in creation of a
can
new
you give me the
appeal.
citation too?
Sir, this is 2021 CLD 214 at para 62-64. But let me come back
Para 62.
to 64. But let me come to, there are two parts to the objection which have been raised. The first part is, where does legislative competence come from? Which end do you rely on? The second part is the problem which your ladyship has raised, which is, what is the constitutional procedure to be adopted to confer this appeal? Whether it's through an ordinary statute or through a constitutional amendment. Let me deal with both objections separately. Let me first come to the objection of legislative entry and legislative competence. If I may draw your lordship and ladyship's attention to entry 50, very kindly, it's quite a complicated entry. मैं अगर इसको जरा ब्रेक डाउन करके पढ़ लूँ,
अगर आप पढ़ते हुए ये एंट्री 55 को एक दफा दोबारा से पढ़ें,
वही मैं पढ़ रहा हूँ सर।
आप उसमें you miss out on the jurisdiction powers of all courts. What do you mean? What is excluded then? अगर हम आपकी बात माने तो फिर तो आप, क्योंकि उसका जिक्र कॉन्स्टिट्यूशन में हुआ है, तो आप उसकी हर चीज को इनलार्ज कर सकते हैं। वो आप बताएं, आप क्या समझते हैं इसके?
और दूसरा इसमें इसी सवाल में अगर पढ़ते हुए टू सच एक्सटेंट एज एक्सप्रेसली ऑथराइज,
जी,
इसके ये ऊपर के साथ पढ़ना है, नीचे के साथ पढ़ना है,
मैं
कहाँ पढ़ना है?
Let us read this entry. Jurisdiction and powers of all courts except the Supreme Court. Now let me stop here. Your Lordship, Ladyship, may just keep your eye on the word jurisdiction and power because it will occur again, but in a different form. With respect to any of the matters in this list. Now, this of course is not relevant only to the extent that enlargement of jurisdiction and supplementary powers have to be understood by the first part. So it's a different thing which is being talked about in the second part when one is talking about the Supreme. Now, the
और
Supreme,
अंडर से पढ़े ना, और अंडर।
जी जी. And to such extent as expressly authorized by or under the Constitution. So this is the first condition, that if you want to legislate under this entry, then you need a conferment by or under the Constitution.
So is it your argument that this by or under would bring in item 58?
No, this is not. But there are two restrictions on this entry. It is not an open-ended entry.
So you're saying that this, to such extent as expressly authorized, is to be read on the first part of the entry relating to the high courts and other courts, or to the Supreme Court?
No, second
or
part.
both?
Second part.
Second part.
Yes.
Okay.
To the Supreme Court part.
Okay.
To such extent as is expressly authorized by or under the Constitution. Now you need to seek this conferment of power from other provisions of the Constitution, either expressed by or necessary implication. But
Entry number
that power,
55 में मिस्टर फैसल ये जो दो लाइनें हैं ना, with respect to the matters in the list, ये तो हो गया बाकी कोर्ट्स के लिए।
ये तो कोर्ट्स के लिए हो गया, ये हमारे लिए
से जो
relevant
शुरू हुआ वो फिर आगे सुप्रीम कोर्ट का तस्करा।
जी जी जी, अब सुप्रीम कोर्ट।
हाँ चल, इसके मानी पे एक्सटेंट के।
और इसमें जो express authorization, the words used are expressly authorized by the Constitution. Where do you get the express authorization from?
Yes,
Who explained
but
that?
it is by or under. That is critical.
No. You see, express means express.
No.
It can't be implied.
By-
When it says express, then it has to be express.
I'll
You
explain.
can't read
Let me
implied
just
into it.
explain the other two restrictions and then I'll come back to this.
I am really enjoying your physical motions. It makes me a little dizzy, but I'm really
Sir, I'm
refreshing
sorry,
also.
sir. I'm sorry.
No, it's okay. I mean,
If
it's
you
just
stop
on the
him,
lighter side.
if you stop him, you won't be able to argue.
No. I just find it very refreshing. Actually.
Sub Article 2 is the only exercise I get, sir. Sir, the first restriction is the enlargement of the jurisdiction of the Supreme Court. Now, your Lordship will see the difference between the first part and the second part. You can't legislate in relation to all matters in any way when it comes to the Supreme Court. It must be, there is a restriction involved. You have to justify the law as enlarging the jurisdiction of the Supreme Court.
But expressly
But
authorized,
expressly,
Yes.
वो बताएं वो कहाँ है?
उसका क्या
Sir,
मानी
मैं
है?
एक मिनट second part पढ़ लूं जी. And the conferring thereon supplementary powers. So it's not that you can legislate on any powers of relating to the Supreme Court. It should be a law that confers powers on the Supreme Court, supplementary.
In addition to what is already mentioned.
Ji?
In addition to what is already there.
Yes. So this is a way to protect the jurisdiction and the powers of the Supreme Court. That if the
पावर दोनों है
Parliament,
ना, एक तो enlargement का भी है, then supplemental powers का भी है, तो
लेकिन सर
दोनों इसी में
एसेंस
आ रहे हैं।
सर दोनों की एसेंस क्या है? दोनों की एसेंस ये है कि आप कमी नहीं कर सकते, आप इस कर सकते हैं।
अभी जरा उसका मानी बताइए ना, जो to such extent as is expressly authorized by or under the constitution. We understand the enlargement.
Yes, the way I understand
इसका क्या मानी?
yes, the way I understand
Mr.
it,
Faisal,
Ji,
it
sorry.
is supplemental powers, not the supplementary powers.
सप्लीमेंटल पावर जी
Supplemental
सर
powers.
दोनों की एसेंस ये है कि सुप्रीम कोर्ट को प्रोटेक्ट किया जा रहा है पार्लियामेंट से कि ये पावर्स घटा नहीं सकें, ये जुरिस्डिक्शन घटा नहीं सके। वो करना है तो कॉन्स्टिट्यूशन अमेंड करें, स्टैट्यूट से सिर्फ पावर्स को बढ़ाया जा सकता है।
But you are saying कि 55 is not applicable.
As an alternative argument 50 I rely on 55।
Faisal, I'm not getting the answer, please.
I'm also not understanding very
सर
clearly.
देखिए मैंने मेरी पहली
As Justice Ijaz Sahab has said, कि first condition is expressly authorized.
जी मैं उस पे वो
So,
दिखाऊं
अगर आप कर दे बता दें कि
ये
अगर ये बात सही
मैं
है
वो
या
बता-
गलत है तो हम
मैं बता Sir, I rely on two provisions of the Constitution for this express authorization under the Constitution and by the Constitution.
Hey, how have you drawn the distinction between by and under?
Under, yes.
How, you are saying by means by the Constitution and under means?
You said under means by implication.
By necessary.
From where have you drawn this? Is this your opinion or are you pulling
My
it
lord,
out of some understanding?
There is a Supreme Court judgment which discuss Indian Supreme Court judgment which I have
No,
cited.
there is a judgment of this court as well, which talks about by or under in terms of Article 240. It has discussed what it is, by or under, what it means. And it says under means, by or under means specifically under the statute, constitutional mandate.
Yes.
Like by some rule of the Constitution or given by some mandate of the Constitution.
Yes,
So it's nothing implied. So your whole argument that this is something that could be implied, it's not implied. By or under the Constitution means something that is expressly provided for in the
I'm
Constitution.
not saying that it's not expressly provided. When you
में
read,
implication तो कोई भी नहीं है.
when you read a certain article,
Article
that
240.
conferment of legislative power necessarily follows from, and when I refer to the two provisions, your lordship will see your ladyship will
No,
see.
Article 240 related to the service of Pakistan, it is only subject to the constitution. इसमें by और under तो नहीं लिखा हुआ।
240A में by or under.
240A,
Learned Council.
जी
तो ये बात वैसे ये
I'm
clear
sure I
नहीं
would
हुई।
not
फिर मैं
be
उस आर्टिकल्स पे आऊंगा तो क्लियर हो
ये
जाएगा।
आइए ना फिर उस पे वो एक्सप्रेसली ऑथराइज वाले को तो
directly उस पे आ जाइए ना जो आपके दो articles हैं.
There are two articles which I rely on for the first condition.
एक्सप्रेसली
One-
ऑथराइज
जी.
जी
First is, if your lordship has read those articles, let me take your lordship again to
Number बता दें।
175(2).
हाँ
175(2).
ठीक और दूसरा कौन सा है
दूसरा है read with Article 141.
141
It is only the parliament which can legislate.
आप 141 इसमें इंक्लूड नहीं कर रहे
नहीं वो अगर आप अपील को प्रोसीजर में इंक्लूड कर देते हैं तो 191 read with
175 का 2 जरा पढ़ लीजिएगा.
सब आर्टिकल 2.
And this is for all courts,
Yes.
including the Supreme.
Yes, and this is how it's been interpreted by His Lordship Justice Hassan Azhar Rizvi. That is where the conferment of appellate jurisdiction comes from. 175(2). No court shall have any jurisdiction save as is or may be conferred on it by the Constitution or under any law.
Council, this 175(2) is also of the same category where it restricts. It doesn't expand. It doesn't confer legislative competence. It restricts the power of the court to exercise jurisdiction to what is provided by the Constitution or, in relevant cases, what is provided by the law. It doesn't expand, it doesn't confer legislative competence on anybody.
My lord, I don't read the restriction or expansion in sub-article 2. I don't see that.
It says
It
no
simply
court shall-
says-
it is
Cast in negative
couched in negative terms. No court shall have jurisdiction.
Yes.
Which means what? That every court would have only that jurisdiction which is conferred by law or the Constitution.
Yes,
So it
but that law
restricts-
can be enlargement of
No,
jurisdiction.
but anywhere else in the
That has to
Constitution
be a
where,
valid law, a law
where
validly
the,
enacted under some other provision. That's
Yes.
the point.
the Constitution is giving competence to Parliament, it's couched in positive words, and it is directly telling Parliament that you can make law on this subject. And those examples were cited yesterday, there are numerous examples.
I think before going to Article 175(2), you have to read Article 142.
141.
142, where the Parliament has the power to make laws. Once laws are made by the Parliament, then no court shall have the.
But those laws have to be related to an entry of the
And
legislative.
191 comes into field and
With
entry
all
58.
due respect, your argument is circular. You see,
Yes.
because you start with entry 55, you go to 175(2), and then you bounce back into 175, entry 55.
Maybe it's a
The
ping
power-
pong
the
day for
law-
you.
Yes.
The law, oh, we are back to ping pong.
It's a ping pong day for
If I
Mr.
may
Faisal.
explain your,
But
because
the law over there has to surely mean validly enacted law.
Yes.
And for law to be validly enacted, one cannot look at Article 175(2). One has to look elsewhere in the Constitution. And wherever that may be, a legislative entry, 191, 188, what have you. All of that is the premise of 172. It can't, 175(2) does not of its own, I mean, that's how I understand it, maybe.
my lord, let me just read a passage from a judgment which explains my argument, and then I'll further explain.
Faisal, I'll just read this sub-article 2 again. No court shall have any jurisdiction save by or under any law. Now, it's, speaking for myself, it's very, very clear that by and under the law, jurisdiction can even be conferred on this court because it relates to all the courts. Now,
इसका सिंपल मतलब ये है कि
the
जब तक
only
आपको jurisdiction
restriction-
नहीं है, जब तक आप सुन नहीं
the
सकते।
only restriction is in entry 55.
Yes.
It can be enlarged.
Yes.
No jurisdiction conferred under the Constitution can be curtailed or in any way interfered with by or under the law.
Yes. Let me
This is
just
how I
explain.
would
Mr. Faisal, you haven't explained the entry, yes. Please, could you just take a little, time to just explain to such extent as expressly authorized? So where is it expressly authorized in the Constitution? Where is it under the Constitution expressly authorized that you could enlarge the jurisdiction under
May
184?
I explain that by reading a passage and then I'll state my argument. 2021,
So I take it that you agree with us that 175(2) does not confer jurisdiction
It
or
does.
competence.
no, it does.
Competence.
It does, it
Okay,
does.
you insist that it does.
No, I
confer
don't-
Competence, even if it is couched in negative terms.
I think negative is a
And it-
relative word.
and it
If
would
it
have to
Says
do-
no court, what
No,
else
no.
could
And,
be a
and
Let
negative?
me- let-
no, and since law can here mean provincial law, it likewise confers it on provincial law. So what is then to prevent a province from saying, we are conferring a right of appeal on the Supreme Court relying on this 175(2)?
Because-
Here is our law, we are conferring a jurisdiction.
Because they would be barred under entry 55.
That's the whole point,
Yes.
that therefore validly enacted law.
Let me explain this, if I may
Tell me
read a
what-
passage. Exactly the same problem came before the court. 2021 CLD 214, para 63. Both these provisions are dealt with.
Section 44 of the Competition Act के अंदर अपील है
जी,
against
जी,
the
तो
appellate
फिर उसमें
tribunal।
यही सवाल आ गया ना कि
मैं उस
Competition
पे
Act-
आता हूँ प्रोसीजर
नहीं, ये जो कॉम्पिटिशन एक्ट ने अपील प्रोवाइड कर दी, जो सवाल ये है कि वेयर इज इट मेंशन्ड एक्सप्रेसली
जरा देखिएगा इसी
in
में
the
जवाब है।
Constitution for-
अगर आप देखिएगा इसी में जवाब।
ये 175(2) के तहत ही enlarge हुई होगी।
जी, अगर आप देखिएगा पैरा 62, it's the exact problem which her ladyship Justice Aisha Malik has dealt with. Exactly the same.
Para 62 is in.
62.
On which page?
293.
293. Thank you.
सर पैरा 62 में मैं पहला पैराग्राफ नहीं पढ़ूंगा, अगर आप देखिएगा एंट्री 55 रिप्रोड्यूस्ड है, ठीक, उसके नीचे मैं पढ़ रहा हूं. There are two parts to entry 55. Have your lordships found?
Yes.
There are two parts to entry 55. The first part allows Parliament to legislate on the jurisdiction and powers of all court in respect to matters in the FLL, which is the Federal Legislative List. The Supreme Court has been excluded from this part, meaning that Parliament cannot legislate on the jurisdiction and power of the Supreme Court in so far as the entries in the FLL. The second part of entry 55 deals with the enlargement of the jurisdiction of the Supreme Court of Pakistan and confirming of supplemental, sir please, confer supplemental powers as well. Article 175(2) of the Constitution states that no court shall have jurisdiction save as is conferred on it by the Constitution or by or under the law. Article 175(2) of the Constitution gives Parliament competence to confer jurisdiction on the court by or under a law. The question is, does this include the jurisdiction of the Supreme Court? When Article 175(2) is read with entry 55 of the first part of the FLL and Article 142 of the Constitution, Parliament is competent to make law enlarging the jurisdiction of the Supreme Court and conferring supplementary power, which is provided by the Constitution by or under the... yes, by or under the Constitution, meaning that the constitutional jurisdiction of the Supreme Court of Pakistan cannot be taken away, but where the Constitution authorizes on jurisdiction, it can be enlarged. So these are the two
question again is,
judgment, has it been assailed before this court?
Yes, yes.
क्या हुआ उसका?
No, it's not suspended, I think, leave grant to me.
इसे निकालिए, ये आप तो चेक कीजिए, ये इसका नंबर ले लीजिएगा, बता दें.
Sir, मैं भी CCP को उसमें leave grant to me, suspend नहीं.
Is it unanimous or is it a unanimous judgment?
Sir, on certain issues,
on this issue,
on this issue, all three agree. All three agree.
Okay.
On this issue, which is given at the last para of her ladyship's judgment, अगर आप वो भी देख लें, उन्होंने बताया किस पे डिसाइड है, किस पे नहीं है.
but Mr. Faisal, my problem with perhaps this judgment also, or otherwise, is that how do you pass this, the test of expressly authorized by or under the Constitution? So what I would understand from this is that somewhere in the Constitution, it must expressly talk about enlargement of the jurisdiction.
Not the enlargement. Not the enlargement.
वो बताएं।
Enlargement and supplemental are restrictions. Apart from that, you cannot. But enlargement of the jurisdiction and supplemental powers is the restriction imposed on Parliament's powers when it legislates on the jurisdiction and powers of the Supreme.
let me just finish with this judgment. Can you tell us the background of this judgment? What had happened?
Sir, जो Competition Act है उसकी वायरीज चैलेंज हुई थी, and one of the provisions which was challenged was that how can a direct appeal be provided from a statutory body through a statute? That was one of the questions.
Sorry, come again.
Sir, how can a direct appeal be provided to the Supreme Court through an ordinary statute?
It was to the Supreme Court.
Yes. And what is the legislative?
Against
Sir, Section 44
Yeah.
है Competition Act.
Against whose order?
Sir, वो
Competition
order होता
Commission
है Competition Appellate Tribunal का.
के ऑर्डर के
So in the nature of a service type matter, direct to the Supreme Court.
Direct to the Supreme Court. Election Act में भी है.
Huh?
But the question which was answered was one of legislative competence. कि कहाँ से power आता है?
इसमें तो अगर आप देखें सिद्दीकी साहब, आर्टिकल 185 में 185 में सिर्फ अगेंस्ट द जजमेंट ऑफ द हाई कोर्ट, लेकिन हम देखते हैं बहुत से कवानीन हैं जिसमें अपील की रेमेडी अगेंस्ट द ट्राइब्यूनल्स जजमेंट, अगेंस्ट द अदर फोरम जजमेंट, डायरेक्ट अपील टू द सुप्रीम कोर्ट. वो पावर्स जो दिए गए, क्या ये सुप्रीम कोर्ट की पावर जो आइन ने दिए हैं उससे हटकर मजीद पावर्स नहीं दिए गए?
That is not what is held in this judgment. But your lordship's question was, if I understand your lord, let's say, and the question before this court, which
if not understood, I will explain it. बात सिंपल सी है कि क्या जो मुख्तलिफ कवानीन के ज़रिए अपील की रेमेडी डायरेक्ट सुप्रीम कोर्ट में दी गई, जबकि सुप्रीम कोर्ट में अपील की रेमेडी 185 में है, जो सिर्फ ये कहता है अगेंस्ट दी जजमेंट और ऑर्डर एंड डिक्री ऑफ द हाई कोर्ट. लेकिन हम देख रहे हैं बहुत से कवानीन है कि जिसमें हाई कोर्ट तो अब फैसला नहीं कि ट्राइब्यूनल्स उसके जरिए अपील सुप्रीम कोर्ट में आती है और वो तमाम एक्ट इन फील्ड है और उस पर अमल दरामद हो रहा है.
My lord, my submission on that, although that's a different question, but my submission on that is there is no such restriction in Article
There is
185.
enlargement of the jurisdiction of the High Court or
Yes.
supplemental
You see, the
powers.
question that
You
was
see, in
raised-
this case, the question was a larger question, and that was whether a federal law can enact and create a competition commission, whether there's competence to do so and whether they can make law on it. The argument was that actually this is a provincial subject and not a federal subject. Hence, the first part of the judgment deals with the competence of Parliament to legislate on the subject of competition. And in doing so, if it can create a regulator, the second part then says that it can also create this right of appeal. So it is not, again, it's not the same context as the case that we are hearing, because this is not creating an appeal to the Supreme Court. It is an appeal from an order of the Supreme Court, which is totally grounded in the Constitution.
But your ladyship has interpreted expressly authorized by or under the
Well, you see,
Constitution.
I don't want to
as-
be explaining what I said, given that this is under
as
challenge.
meaning Article 175(2). That is exactly what Justice Hassan Azhar has
अच्छा, एक
done.
चीज
in
मुझे बताएं.
You're
What
putting
is
meaning to something that may not be there.
Faisal Sahab, just sorry, I'm not very familiar with this matter. If you can just tell us what was the objection, who taken to this decision on this score? What was the other side's point of
The
view?
objection, I think, was that these are appeals to the Supreme Court which can only be created through a constitutional amendment. And this was one of the objections.
अच्छा, ये बताएं कि अगर ये कानून में ये ऐसा
There were other objections.
if this law had said the appeal will lie to the High Court, it would have been okay.
This was not the objection. It was
Then-
that it's a provincial law and not a federal law. That was the objection.
I mean, the leave granting order also takes that as a question.
That was it. In fact, Mr. Bhandari even mentioned this the other day. This is precisely what the case was. He argued the case before it.
चल हम देख लेंगे
And
उसको
try
मतलब-
hard.
But
Without any luck.
Right.
But the issue was that
It
when
was
it
on
comes,
who's competent, the federal government or the provincial government?
but when it comes to the interpretation of the words expressly provided by or under the Constitution, the only
Faisal,
article which
Mr.
this
Faisal.
judgment relies on is Article 175.
Mr. Faisal, what I would like to ask repeatedly, the question is that whenever you set, is that how it is, that whenever you set out, law sets out to enlarge the jurisdiction of the Supreme Court, it is to pass the muster of these two conditions, that is, there must be an expressly authorized by or under the Constitution, which I don't know how it happened in the Competition Commission, but that aside. In this particular case, where is that express authorization or by or under the Constitution which would allow the enlargement of the jurisdiction of 184? That's what I'm asking you, what does this line mean?
Sir, your lordship is reading the entire line without the comma.
Okay, so how do you want to
Yes.
read it? That's
If
what I
your-
want to know.
If your lordship may kindly see that there is a comma before the enlargement,
Yes?
to such
So you're saying that
extent,
is separate, as a standalone?
that's a condition that you cross. You must have to show an express authorization by or under the Constitution.
Where is that in this case?
That to me lies in Article 175(2).
Acha, acha, acha. Now, chalo, ठीक है.
And that is exactly what these two judgments
The
say.
judgment does
Mr.
not say
Faisal.
that, Mr. Faisal, आप उसको गलत, it goes under the federal legislative list. That's from where it derives its competence as per this judgment.
Mr. Faisal Siddiqui, I'm here.
Ji, sir.
Yeah, the bare reading of Article 175(2) suggests there are two streams which are conferring jurisdiction on the court. One is the constitutional instrument and the other is the statutory instrument. दोनों स्ट्रीम से जुरिस्डिक्शन आ रही हैं। अब एक स्ट्रीम की दी गई जुरिस्डिक्शन से हम क्या दूसरी स्ट्रीम की जुरिस्डिक्शन को अमेंड कर सकते हैं या एनलार्ज कर सकते हैं? स्टैट्यूटरी लॉ के जरिए दी गई जुरिस्डिक्शन और एक कॉन्स्टिट्यूशनल लॉ के जरिए दी गई जुरिस्डिक्शन, दो जुरिस्डिक्शन है हमारे सामने। अब स्टैट्यूटरी लॉ के जरिए हम कॉन्स्टिट्यूशनल जुरिस्डिक्शन को एनलार्ज कर सकते हैं, नंबर वन। नंबर टू, दो लफ्ज इस्तेमाल हो रहे हैं, बाय द कॉन्स्टिट्यूशन और अंडर द कॉन्स्टिट्यूशन। Do you agree that when a jurisdiction is to be conferred on any court, it is given by the constitution or by the law? And how it is to be regulated? The answer is under that statute or under that constitution provisions. The under is conveying the idea of how to regulate that jurisdiction. It is not merely implication. Do you agree with this?
Yes, there are two questions.
Yes.
Now, I would agree with the first position of your lordship if there was a restriction in the constitution itself that there is a bar in the constitution itself that no appeal can be provided. For example,
I'm not talking restriction, enlargement. You want to
sir,
enlarge it.
let's take the example of the law reforms ordinance. Now, Article 199, as His Lordship Justice Mandokhel pointed out, it's a constitutional judicial forum. Now, the appeal under that is provided under a statute.
You see,
If you're,
Mr. Siddiqui, law reforms ordinance is a totally different species. It was a continuation of letters patent. It was a continuation of other provisions, and plus, subsequently, it was saved under Article 270. So, I mean, there are no parallels. I mean, you are comparing apples with oranges.
sir, I'm comparing apples with apples, and I'll explain why.
Certainly, you're trying to do, but as far as I'm concerned, I'm so far.
You compare Granny Smiths with Granny
Siddiqui
Smiths.
साहब,
But the question, you know, again, I mean, reflecting, adding to
I'll
what
come
my
to the
learned
second
brother was
part
saying.
also.
You see, here you're creating a jurisdiction for the reason that the appellate jurisdiction is provided in 185. Fine. Now, 185 does not either talk of, it neither talks of an intra-court appeal, nor it talks of any other appeal envisaging something happening within the Supreme Court. What you're doing is, you're creating a new jurisdiction.
Yes.
You're creating,
Yes.
you're not enlarging. And when there is a creation, then the creation can't be done under item 55.
Enlargement of
And it cannot be done in exercise of powers under either 175(2) because that is also restrictive, and Article 191, that is also restrictive. So there are restrictions all over the place, and intentionally so.
My lord,
So that if an appeal be provided where the lawmaker or the framers of the Constitution consciously, deliberately did not provide one, then the matter should go back to them, and under the new circumstances, if they consider it appropriate, they can amend the Constitution and specifically provide an appeal. Using supplemental powers, using ancillary powers, I mean, that is, I think, stretching the Constitution much what it
my
is
lord,
originally
my
designed
response to
for.
the latter questions is, there is no bar under Article 199. There is no bar under Article 185. There is no bar under Article 184(3) that you can't provide an intra-court appeal through an ordinary statute. There is no bar.
Mr. Faisal Siddiqui.
Where is the bar?
Where the language used is express authorization, that is the bar. But you have to have express authorization within the Constitution in order to utilize
What more
the
express
powers
bar is
available.
required than Article 175(2)?
175(2) does not confer
Mr. Faisal
legislative
Siddiqui,
competence.
if I may add to what my learned colleague is saying, you see, it seems to me that the proper context of this sentence from this judgment at page 293 that you are so strongly relying upon, and with great respect, I think you are taking it out of context. But anyway, I think that is perhaps expanded upon at page 295. kindly
पैरा
उसमें
अगर
जो-
बता दीजिएगा.
पेज 295
सिर्फ वो-
पैरा 63 इसमें जो अंडरलाइन पोर्शन है ना वो जरा देखें. इसमें एक जजमेंट सुप्रीम कोर्ट की रेफर्ड टू है और उसके बाद उसका आई डोंट नो वेदर इट्स कोटिंग फ्रॉम इट्स कोटिंग फ्रॉम अ जजमेंट. वो उसमें देखिए जिसको पैरा अंडरलाइन किया हुआ है जो
जी वो
I
2000 SCMR जो कोर्ट की.
उसमें उसके अंदर शायद दैट एक्सपोर्ट्स दैट 175 point in proper context.
Yes.
पढ़िए तो सही. सुखाली पढ़िए. ये जो अंडरलाइंड है ना
Under entry 55 of
under entry
Federal List.
55 of the federal list. ये
Sir,
290.
I'm sorry, I actually have the.
Page 295 जहाँ
अगर आप
63
पैरा
में
kindly अगर
reproduce
बता
हुई
दें.
नहीं है ना?
Para 63,
63 का second,
para 63.
second column, second column, third paragraph.
इसमें if the entry 55.
If entry 55 was not there in the FLL, it could be argued that Article 175, 2 of the Constitution in respect of matters relating to cooperative societies exclusively failing under the competence of the provincial legislature, a law can validly be made by the provincial legislature, enlarging jurisdiction of the Supreme Court and conferring on its supplementary powers. But Article 175(2) is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and the entries in the legislative list. Under entry 55 of the federal list, federal legislature is competent to make laws regarding jurisdiction and powers of all courts except Supreme Court with respect to any of the matters in such list. The other part of the entries makes the federal legislature competent to make laws enlargement of the Supreme Court and conferring thereon the supplementary powers with the proviso that this is to a cell is expressly authorized or under the Constitution powers and jurisdiction conferred on the Supreme Court by the Constitution can neither be inferred with or varied or taken away by legislature. However, jurisdiction of the Supreme Court can be enlarged and supplementary powers can be conferred on the Supreme Court by law in view of Article 175(2) of the Constitution and entry 55 read with Article 142A of the Constitution leaves no doubt that such enlargement of the jurisdiction and conferment of supplementary power can only be done through law made by federal.
So this is the point, I think. This explains the context of what that sentence says, because what this passage is telling us is that the jurisdiction of the Supreme Court can be enlarged. 175(2) does not do that, but for that there must be validly enacted law, for which you have to look not to 175(2) but to entry 55 read with the Article 142A. So this is the context.
142A says you look at the entry.
That's what I'm saying.
Yes.
The two have to be read together.
Yes.
But what this passage makes clear is
Yes.
that 175(2) is not a standalone power jurisdiction, because at the beginning of this para, the Supreme Court gives the example, if that were so, which is what I also put to you, then law could include provincial law, and therefore a province could say, well, we enlarge the jurisdiction of the Supreme Court. Supreme Court is saying, no, that is not correct. That 175(2) is not independent. All that it tells us is, yes, jurisdiction can be conferred on any court, including the Supreme Court by law, but that law has to be 55 and 142.
142A. There is no other third provision which is cited for the Competition Act.
लेकिन आप जो कह रहे हैं ना, आप जो उस जुमले को जो पढ़ रहे हैं at page 293 पे, as though that is intending to give a standalone competence in terms of 152. I don't think that's correct.
Mr. Faisal Siddiqui, if I go along with that, actually, so therefore, I don't understand how Competition Commission can confer a jurisdiction on the Supreme Court.
That's a big problem.
Unless it cannot, because it has to be, we have to pass through the same test as we have to pass today, that is expressly authorized or by or under the Constitution. So if 175 is out, then where is that expressed for, even for competition, election, and for the other four different statutes
There
as
is
well as
also a law,
184.
Faisal Siddiqui Saab, there is also a law, Newspaper Employees Condition of Service Act 1973, in which also the appeal is provided direct to the Supreme Court. There is no appeal in the High Court, but it is against the conviction awarded by the Implementation Tribunal. So this is also direct appeal under Section 13A of the Newspaper Employees Condition of Service Act 1973. So competition, newspaper employees, contempt of court. There are three laws at least.
Yes,
And there are
this,
two- and there-
since nobody has given us me the background, there's a competition commission has given authority to the Supreme Court or the Act?
No, the Act. There is a provision, Section
Okay.
44.
And the argument from the other side is, since it is a provincial act, it cannot confer such jurisdiction. Is this the argument?
सर मैं हाई कोर्ट में नहीं था इसलिए मैं ज्यादा कहना नहीं
लिखा क्या
चाहूंगा
जजमेंट में उससे?
उधर एक ऑब्जेक्शन ये ली गई थी पिटिशनर्स की तरफ से।
One of the objection was how is a direct appeal provided in the Supreme Court.
So,
The other was also about who has legislative competence,
It was
whether the
about
federal.
legislative competence.
Yes.
And in that context, the rest of the provisions of the law were challenged.
Yes, yes.
And so the judgment aims to show how the subject of competition falls under the legislative list, and therefore from there derives power to.
Mr. Bhandari, were you the counsel in this case? Can you just explain me don't argue the case, just explain me the fact of this matter. What was the objection taken?
Well, to this particular provision, the primary objection was that under the scheme of the Constitution, the High Court can't be bypassed in the appellate hierarchy. So the first appeal must be provided to the High Court under Article 185, to the High Court, and then from the High Court's judgment, the appeal should come to the Supreme Court. What has happened is...
No, so that was the case. So
that was
if
the... No, my
No, वो बाकी बातें नहीं, मैं सिर्फ ये, I was just trying to understand the fact.
On the
Now,
question of appeal, that was the primary argument.
Just 1 second. Now, since the matter of competition, right, since goods travel across borders and that's specifically permissible, mandated by the Constitution. Now, if different competition commissions, even let's say there are 4 or 5 competition commissions in Pakistan, and matters start going to the High Court for different determinations, would there be fundamentally anything wrong if a province, for the sake of argument, or all the provinces confer the jurisdiction on the Supreme Court?
My lord, under the scheme of the Constitution, that can only be done through Article 144. Yes. All the provinces will have to pass resolutions for an act of parliament to be framed in terms of Article 144, and then that too would have to pass through the test of entry 55. Draft mein.
So that could be done.
There is a possibility. The Constitution provides a way out for that.
Okay, just wanted to understand it. Thank you.
Entry 55 problem would remain in terms of appeal to the Supreme Court.
Yes.
Yes, that
As
remains.
opposed to Parliament making a competition law is a separate question which could be addressed by 144. But the question of an appeal from appellate tribunal to the Supreme Court, that would still remain.
तो फिर entry 55 के टेस्ट तो फिर भी meet करने पड़ेंगे.
Entry 55 is
जी, वो तो
still in
करने
the way.
144 में भी जाएंगे तो entry 55 के थ्रू गुजरना.
वही फैसल साहब से पूछ रहे हैं, 55 का टेस्ट क्रॉस करें ना.
Faisal Saab, you are the
Express authorization पे
Faisal.
बात नहीं बढ़ रही।
I have 2 questions. If 175(2) is read with entry 55, is that not sufficient authorization expressly given to the Parliament? Second question is that the expression used in entry 55 is enlargement of jurisdiction. Can you give an example how the jurisdiction, there are basically 3 different jurisdictions of this court under the Constitution. How can the jurisdiction be enlarged? Any example?
Sir, appellate jurisdiction enlargement, one of the forms of enlargement of appellate jurisdiction would be creation of a new appeal. I mean, how can that not be considered as an enlargement of appellate jurisdiction? I mean, your lordship is going against the settled principle of interpreting an entry, which is a very narrow meaning given to a word in the entry.
If an appeal was provided or envisaged under orders passed under 184(3) in the Constitution, yes. Now conferring a jurisdiction would essentially mean you are amending the Constitution.
Where is the bar in 184(3) that no appeal can be provided by an ordinary statute?
Why don't
Where
you?
is the authorization?
Learned Counsel, let's.
When you need to provide an appeal or an enlargement, you have to fall on entry 55.
Yes.
And entry 55 says there has to be an express authorization. So that takes care of where is the bar. Bar is there because it says you have to have express authorization within the Constitution.
Sir,
So,
I leave this point. My express authorization lies in two provisions. 175(2) read with Article 141, because only the Parliament can make a law which relates to the Supreme Court, because it's a federal
ठीक है,
institution.
you want
Now
to,
I move forward.
yes, चलिए.
Sir, okay.
आप कितना और वक्त आपके पास चाहते
Sir,
हैं?
I finished the competence part.
Can you just give us your own time?
Sir, I would like to
Needless
finish-
to state
No, sir,
how
I
many
would-
questions, huh?
I'll finish in an hour, sir. If your lordship may kindly
So
give
we
me.
can either take a break and come back.
Yes.
Is
Mr.
this a good?
Siddiqui, Article 10A has any connection with conferring
Nahi,
power to
bana
the
diye
Supreme
nahi.
Court regarding appeals?
Sir, I would not like to go down that route that fundamental rights can be used in order to conferring legislative power, because fundamental rights are so widely worded that the entire legislative list will disappear if that interpretation is
10
taken.
past 2 we will convene
Ji,
again.
ji, sir.
ठीक है, 10 past 2.
Thank you, sir.
Thank you.
Half an hour.